this is the last day that you have with me. We have a full schedule, so we'll be going through a lot of things today, and I think it might be that you at some point feel overwhelmed by everything that is going to be thrown your way today. But please bear in mind again that these are basic principles. So what you should be able to do when we're done today is you should be able to take a step back and say, I understand the civil procedure from an action being instituted right up to trial. We're not dealing with trial procedures in this program. I think there's at some point you'll deal with trial procedures and things at a later stage, not with me. I'm dealing with you with the civil procedure from instituting an action right through to trial. And the most important part thereof is you must understand the sequence of pleadings and the basic principles relating to pleadings. So how pleadings are exchanged, when they are exchanged, and what the purpose of these pleadings are, and the requirements for these pleadings. You don't need to be able, after this is not a legal drafting course, you don't need to go and draft the particulars of claim with exact precision, but as a judge you will be faced with particulars of claim and you need to know whether they were drafted with the requisite precision. Then very importantly is you need to understand fully the judicial case management system. Now, reading it on paper, and I know exactly how you feel, because as practitioners coming from a previous dispensation where we didn't have case management, it was a completely foreign concept. And I remember the first time I sat in a meeting, and remember I'm a litigant or a representative of a litigant who appears in court often, so I understand the procedure because the only way to really learn procedure is through experience. But the first time I heard the term judicial case management and I read the proposal on paper, I thought, what is this? How is it going to work? It's never going to work. We were all very concerned. And once we saw it in practice, it makes a lot of sense. So what I'm trying to convey to you is what happens in practice, because that really brings this abstract idea of judicial case management to something concrete that you can work with. So I understand, and I'm sure in the exams we will keep that in mind, is that you don't many of you haven't practiced or haven't witnessed the practice of judicial case management in practice. It really is as simple as I try to make it. It's just that when you read it on paper without seeing something concrete on the ground, it can seem a bit daunting and abstract. So just to catch up where we are, I told you yesterday that judicial case management happens in 3 phases: the case planning conference, the case plan and case planning conference, case management conference, and the pretrial conference. So these are the 3 stages of judicial case management. This starts right after notice of intention to defend is filed, so there's no need to case manage an unopposed action. It's unopposed. Default judgment is going to be granted. So it's unopposed, no need to deal with, to judicially manage that case. Once an action is defended by the filing of a notice of intention to defend, automatically this process kicks in. Automatically it's docket allocated, so automatically that file is allocated by e-justice to a judge, and the judge then is seized with the matter and with the judicial case management of that matter. And then the overriding principles come in. That's where you need to understand what the overriding principles of case management is. Why do we have the system? We have the system so that it's judge-driven to get the ducks in a row. The judge isn't going to get the ducks in the row for the litigants, but the judge is going to force the litigants to do that within a reasonable time and in the most cost-effective manner possible. So it really is that you should have a pragmatic approach to managing cases. It happens often in practice that the permutations of a case and the idiosyncrasies of a case dictate that what the rules prescribe don't necessarily always fit in to what needs to happen. And in those cases, you need to understand that you need to regulate the management within the bounds of the rules and sometimes make exceptions to the rules. Remember, inherent jurisdiction, regulate its own procedure. The court is there. The rules are there for the court is not there for the rules. So you, unlike a magistrate's court setting where you are very much kept in line by it being a creature of statute and you have to operate within the bounds of that statute and you can't regulate your own procedure, etc., etc. Unlike that, you're in the High Court now where you are able to manage. So it really is getting a feel for these objectives of case management, knowing what the rules are and knowing how you can work with those rules and sometimes outside those rules to make sure that justice is done between the parties and the speedy and cost-effective administration of justice. That is, in a nutshell, the purpose of case management. So in the example I gave you yesterday, you saw that in certain instances, for instance, with the case plan, it may be that you have to revisit that or that rights arise after the case plan. These things happen in practice, and you need to know how to work with that and around that. All right, so case planning we did. Docket allocation, Rule 21. I'm not spending a lot of time on that. You need to do that self-study. Know that once a notice of intention to defend is delivered, then the matter is docket allocated to a managing judge. Once a managing judge has been appointed, that managing judge will be seized with the matter throughout this process, unless it's handed over for whatever reason. Perhaps there's a recusal or the judge is no longer available or whatever. But generally, once it's allocated to a managing judge, that managing judge will deal with the matter and be seized with the matter. That is not to say that that judge must hear the matter when it goes to trial. So the trial judge may be someone different, because what happens in practice, matters are set down and all the floating roll matters are called by what we call roll call on a Friday, and the judge who's sitting in a roll call will hear which matters are proceeding. All those matters will then be distributed amongst the available judges to do the trial in the coming week. So it's not to say that the judge who is seized with case management will then also conduct the trial. That's not a rule. All right, so we did case planning conference, Rule 23. We dealt with how it's submitted, when it's submitted by whom, and the effect of not setting out a procedural step. He just picks up where the other judge left off. So it happens sometimes that they go on leave or become ill or whatever the reason may be, that they're no longer available, and then someone would stand in and just carry on where that judge has left off. Okay, so then we dealt with the case management conference, Rule 25, which also these two don't really deal with a lot of the substance of the case. It deals with purely procedure, or perhaps better to say logistics. Both of these deal purely with logistics. It's not going to deal with the merits of the case. It deals with logistics. What are you going to do and when you're going to do it? This one is logistics prior to close of pleadings. And this one is logistics after close of pleadings. Okay, that's what we've been dealing with yesterday. So it's logistics. If you look at what is set out in the case plan and in the case management report, then you'll see that it is really just dealing with logistics. Who's going to do what? And why are they going to do it, and when are they going to do it? That's what's happening. Now we're moving over to the pre-trial conference. Now here we're getting into the thick of things. Here we're dealing with the essence of the matter. And we're basically getting the matter ripe for trial, and we are crystallizing the issues. Okay. So this one is the big brother of these two. Okay. So generally, what would happen in a case management process, in order to curtail costs, when it's a sort of a run-of-the-mill type of action that is also that I'm now instructed in as instructed counsel, then I would leave these two over to the instructing practitioner, the lawyer. He or she would ask my input in the dates and certain issues that may arise. But generally, this is sort of a not very complex procedure, and that can easily be dealt with. And also appearances are then done by, more often than not by instructed counsel in order to curtail costs. I would appear in a case planning conference or in a case management conference where it's a matter of complexity or issues arise that I need to address the judge on. But for the run-of-the-mill, no issues, there are no issues to really be determined or to address the judge on, then the attorney will generally deal with these. But here you need to sit down. Here you need to think. This is a much more complex procedure, and that's what we're going to deal with today, starting off, is what we call the pre-trial. Okay. So you can, let's just, matrimonial matters. Remember that in matrimonial matters, there are additional issues that you need to address in your case management conference. I'm not going to deal with them, but you would be able to find them in the rules. And then also status hearings we spoke of briefly yesterday. So status hearings can be called by the judge. They can be called by the parties can request the judge to call a status hearing. So they don't call status hearings, but they can request the judge seek an indulgence for a status hearing to be called. And status hearings, as I've said yesterday, are called in order to determine the status of the matter, to address an issue that may have arisen prior to the next hearing and something that needs to be addressed now. So it's a very handy tool, and it assists the parties. It provides a mechanism through which both the judge and the litigants are able to keep abreast with what's happening and deal with issues as they crop up. All right, and then you get the pre-trial conference. So the pre-trial conference, it's Rule 26. It relates to the final set down of the matter. So essentially, a matter shouldn't be set down for trial until the pre-trial conference has been finalized, and there's a pre-trial order made. So what the parties are required to prepare when it comes to the pre-trial conference is called a draft pre-trial order. So it really is, and the parties prepare what they think the judge should order at the pre-trial conference. Now, of course, in all these scenarios, but particularly in this scenario, the parties are required to meet. Now, obviously, that doesn't always happen in practice. The parties don't actually always sit around a table, because if it's a run-of-the-mill type of case, a normal motor vehicle accident or whatever, the issues are fairly straightforward. Then the parties, the dominus litis, the plaintiff, would usually draw a draft pre-trial order and then send it to the defendant to look at and to see whether they want to make additions or changes. And then the parties sort it out amongst themselves. In more complex matters, you would find that the parties meet already at case planning stage and at case management and a pre-trial. So, of course, it is, it is, of course, prudent that the parties meet. And this shouldn't be overlooked. The importance thereof, many issues may be discussed and sorted out during such a meeting, but that essentially is what the process prescribes. So you'll have the parties meet, and what they do at a pre-trial conference, and let's just open Rule 26 for the moment. So a trial, as you will see from Sub-Rule 1, a trial cannot be, or matter cannot proceed to trial or hearing unless there's a pre-trial. Now, of course, you won't do case management of interlocutories in that you have a case plan. If it's an interlocutory matter, you're all acquainted with the term interlocutory matter. Or is there anyone who wants me to explain what the term interlocutory means? All right. So interlocutory would mean it's not a substantive application, so it doesn't exist in its own right. It's subject to main proceedings. So if there were no main proceedings, the interlocutory application wouldn't be in existence. Even though it may finally dispose of the matter, that's not to say that it's not interlocutory. So it really is a matter that's incidental to main proceedings. Now, our interlocutory doesn't have its own case plan, case management conference, and pretrial. That's the main action that has these steps. The interlocutory is managed by the managing judge, but for that we won't find any of these 3 steps. It's managed on an ad hoc basis. All right. So a trial, an action, won't be set down for trial or hearing before a pre-trial is concluded. And then it's held, and it's in sub-rule 2 in terms of Form 7. You can read the requirements there. And the parties must address the issues set out in sub-rule 6, the parties' proposed pre-trial order, and any other issue that may promote a fair and speedy trial. So the parties are not limited to what's set out in sub-rule 6. They can address more issues, and often they do, but they shouldn't address less than what's set out in sub-rule 6. So sub-rule 6 says it must be all issues of fact to be resolved during the trial, all issues of law to be resolved during the trial, all relevant facts not in dispute in the form of a statement of agreed facts, the names of all witnesses who may be called to testify at the trial, and the proposed dates for the filing of witness statements. The witnesses to be called by subpoena to testify, evidence taken on commission, a list of all exhibits intended to be introduced as evidence during the trial, all plans, photos, diagrams, and models to be introduced as evidence, the anticipated length of the trial, time limits for delivery of the index and paginated pleadings, any proposal for expediting the trial or hearing, particulars required for trial, prospects for settlement of the case, and the need for transfer from one division to the other. So these are the things that you need to address at your pre-trial stage. Now, let's turn for the moment to page 55 under the case management section of the file that you were given. So this is what a draft pre-trial order or proposed pre-trial order looks like. You'll see here the parties said that the issues of fact to be resolved in this matter was the negligence of the second defendant, and if so, did it cause or contribute to the collision, the negligence of the plaintiff's son, and if so, did it cause or contribute to the collision, the parties' respective quantums of damages, the plaintiff's ownership of the Suzuki vehicle bearing that registration number, then the issues of law, whether the court should make a ruling in terms of Section 1 of the Apportionment of Damages Act, and then 3, the following relevant facts are not in dispute, the citation of the respective parties, the time, date, and place of the collision and the vehicles involved therein, that the parties' vehicles sustained damage in the collision. The first defendant is the owner of the Volkswagen transporter vehicle with registration number that. The first defendant is vicariously liable if second defendant is held to have been negligent, and the plaintiff is vicariously liable if her son is held to be negligent. And then, now let's perhaps stop there for a moment. When you deal with the issues of law and issues of fact to be resolved, in other words, that's what you're saying to the judge, that is what the parties want the court to look at and decide. Now, if you just turn back to the pleadings, you'll find the particulars of claim on page 3 to 5. And then you'll find the plea on page 12 onwards. And then there's a counterclaim. We won't deal with the counterclaim just yet. So you'll see, that the particulars of claim state, these are the parties. Then at all material times, the plaintiff was the owner, alternatively the bona fide possessor of a Suzuki Swift motor vehicle bearing that registration number. On or about 17 October and at Windhoek, and at the intersection of Robert Mugabe Avenue and Jan Jonker Street, a collision occurred between the plaintiff's motor vehicle, then and there driven by Marcel Josia, and the first defendant's vehicles, then and there being driven by the second defendant, acting within the course and scope of his employment with the first defendant, alternatively within the risk created by such employment, in the further alternative as an agent acting on behalf of the first defendant. And then the aforesaid collision was caused solely as a result of the negligence of the second defendant in one or more or all of the following respects, and then they list the respects in which they allege the second defendant was negligent. As a result of the second defendant's negligence, the plaintiff's vehicle was damaged and suffered damages in the amount of 144,000, being the fair and reasonable value of the motor vehicle as set out in Annexure HJ1, and therefore the first and second defendants are liable to the plaintiff. That's the claim. The defendants then answer and say they admit the citation of the parties. They admit the registration number of the plaintiff's motor vehicle, but they deny the rest. They admit that a collision occurred on that day, as set out in paragraph 5. There are two paragraph 5s. Then the second paragraph 5, they deny, and they refer to their counterclaim, and they say alternatively, contributory negligence. Then add paragraph 6. They admit the registration number and that it was damaged, but deny the quantum. And then paragraph 7, admit demand and failure to pay, but say that they are not liable, and therefore that the plaintiff's claim should be dismissed. Now you'll see that basically what they're saying is that the second defendant is employed by the first defendant, that a collision occurred on that date between these vehicles driven by these people, and that as a result both parties' vehicles were damaged. That's what they admit. Now, and then there's a counterclaim for negligence. Now, if you go back for the moment to the draft pretrial order, it says the issues of fact to be resolved during the trial: negligence of second defendant and negligence of plaintiff. But the negligence really is more than just the negligence, is it not? Because the negligence, if you look at page 4 of the pleadings, it's set out to say these are the regards or the respects in which it is alleged that the second defendant was negligent. So it's really much wider in the pretrial order than it is in the pleadings. So a party can't amplify his pleadings by way of the pretrial. So they will be bound by what is in the pleadings. The pretrial doesn't somehow override or widen or broaden or augment the pleadings. So a plaintiff in this respect, although it's said that it's only it's the negligence of the second defendant that must be established as a matter of fact in an issue to be determined, what will be determined is what is set out in paragraph 5 of the particulars of claim that says he failed to have regard to road users, he ignored a red traffic light, he failed to avoid a collision when it was reasonably expected of him to do so, and he drove the first defendant's vehicle without a valid driver's license and therefore illegally. These are the grounds on which it's alleged that he's negligent. So you can't then at a trial, because there's a wider reference to the issue in dispute in the pretrial, suddenly say, but now I want to go wider than what's in my pleading. Now, the rule requires the party, when you look at the following facts not in dispute, the rule requires a sort of a stated case to say the citation of the respective parties. That really is, strictly speaking, not rule compliant. Because what the parties need to do is to draft a statement of the facts that are not in dispute. So the plaintiff is this person, the first defendant is this, the second defendant is this. This is when the collision occurred between these motor vehicles bearing these registration numbers, and the second defendant is the first defendant is vicariously liable based on this, and the plaintiff is vicariously liable based on this. So listing it in the way that it's listed here is not strictly rule compliant, although the issues are properly listed. So you see how the pre-trial ties in with the pleadings. Does that make sense? And that's what it's based on. So drafting a pre-trial order requires the parties to go to the pleadings to establish what's in dispute and what's not in dispute. List those things that are not in dispute in the form of a statement of facts, and those things that are in dispute distinguish between what are issues of law and what are issues of fact, and then list them. It's not a regurgitation of the pleadings relating to the issues in dispute, although that does happen sometimes. Okay, so you follow. Okay, so let me explain by way of an example in a matter that I previously had. I was a defendant. I acted for a defendant in a matter where the plaintiff had relied on certain. It was a claim for specific performance. Then it was an invalid cancellation. The plaintiff said the defendant cancelled the agreement, but it did so unlawfully, and therefore to repudiation of the agreement, and the plaintiff didn't accept the repudiation, and therefore the agreement is. Then, in the pre-trial order which was drafted, there was reference to something which dealt with not an election or a waiver, but an acceptance of a certain document. So the defendant said you had to provide a guarantee, and you didn't comply with that. But the plaintiff attempted to comply by granting some letter of undertaking which wasn't relevant, or which the defendant said wasn't in compliance. But the official working at the defendant received the document, and then it was pleaded to say, well, yes, we admit that he received the document, but that doesn't constitute acceptance of the document. It doesn't mean that he accepted it, he received it. Now that acceptance then, during trial, was elevated by the plaintiff, or attempted to be elevated by the plaintiff, to an election or a waiver, which is different from I have complied with the agreement to, well, I haven't complied, but you've waived your right to rely on breach. So once that evidence was being presented, I obviously objected. I said that's not the case that the defendant was called to meet by the plaintiff. So one of the things that the plaintiff tried was to say, well, this acceptance reference in the pre-trial as being an issue in dispute really means election or waiver. And then they tried to amend their pleadings to bring in the election or the waiver, which you know you must properly plead in your particulars of claim if you want to rely on that. And of course the court at that stage didn't allow the amendment. But so a party won't be able to move outside the pleadings and amplify the pleadings by way of the pre-trial order. The parties are bound by what they set out in the pre-trial order, so parties must take care and in drawing draft pre-trial orders to make sure that they're actually in strict compliance with what is required. But if something is in the pre-trial which is not in the pleadings, it may assist a party to move for an amendment of the pleadings, because remember, the overriding objective of case management is to determine the real issues between the parties. And the court will obviously take that into consideration in an amendment. But you will have to amend your pleadings if you want to rely on something that's in the pre-trial conference but not in the pleadings. Okay. So, as I said, pre-trial conference deals with the essence of the merits. Parties will have to analyze, physically analyze, the particulars of claim, the plead, the replication, the counterclaim, the plead thereto, replication, all the pleadings filed. And we'll have to, from that, make a list of the issues that are in dispute, formulate them and list them, You obviously don't want to overburden by regurgitating or overcomplicating the matter. You simply formulate them and crystallize them because you want to delineate all the issues that are in dispute. Then you need to classify whether these are issues in dispute relating to fact or issues in dispute relating to legal issues, and then list them accordingly. Sometimes an issue can be a combined issue of law or fact. So when you can't really force that issue into either fact or law because it has an element of both, like negligence. Negligence is a question of law and fact. So that could be then say issues in dispute of combined factual and legal nature, and then those are listed. And then the pretrial then, if you look at what's required, gets the matter ripe for trial. So it deals with all the preliminary issues that must have been dealt with in order for this matter to be ripe for trial. That includes paginating, indexing. So it has an element of dealing with the merits and crystallizing or delineating the issues. And it also has a logistical element in that it just does the final steps. So there is authority. You can actually just look for it. It's a number of authorities, and I think the one most quoted is one by Judge Smuts while he was still at the High Court. I'll look for the citation during the tea break, where it's clearly stated the pretrial order becomes an agreement between the parties. So the parties are bound by what is set out in the pretrial, and they can't simply deviate from it. And now remember, if subsequent to pretrial pleadings are amended, it would mean that the parties would similarly have to amend the pretrial order because other issues become issues in dispute, and other issues may no longer be in dispute. So that would entail also an amendment of the pretrial order. If you look at the issues that are not in dispute, so have a look at what is required in terms of rule. Look, I'm being extremely formalistic now. You, as a judge, you would obviously look at the case. This is a simple motor vehicle accident claim. It really is no effort to go to the particulars of claim and see the particulars of the litigants. That is not in dispute. So, but strictly speaking, if you look at what is required, you can look at Rule 26, Subrule 6, and then C. All relevant facts not in dispute in the form of a statement of agreed facts. So you would have to have all the facts set out in a statement form. Say these are the facts that are not in dispute, and then list the actual facts. They are simply saying the citation of the respective parties. Now, where must the judge go find the citation of the respective parties? The judge must now page back to the particulars of claim to go look for it. So the parties should strictly, as I said, I'm being very formalistic now, but that is what the rule requires. The rule actually requires you to draft this in a manner where the facts, the judge should be able, at the end of the day, to take this page of the pretrial order where it says the following facts are not in dispute, and to take those facts and literally copy and paste them into a judgment to say, these are the facts that are not in dispute, and list them. But now it's only the citation. So, okay, this is a fairly simple matter with very little pleadings, and it's easy enough to go back to the citation of the parties. But can you imagine if it's pleadings that go into 200 pages, and that often happens, and there are 90 facts not in dispute? Can you imagine if the judge now has to page back and forth to find these in the pleadings? So it's not helpful then. It's not helpful then. The purpose of this is to be helpful, to be of assistance to the court, and to make matters easier. So at the end of the day, you can pick up your pretrial order and you can look at exactly what needs to be done at the trial and what you can rely on and what you can't rely on. And you shouldn't have to page back and forth looking for facts. Of course, you need to be able to test whatever is stated in the pretrial order against the pleadings. But you would obviously be entitled to rely, or should be entitled to rely as a matter of assistance to the court. That's why I said it's not strictly rule compliant if you look at how the issues not in dispute are formulated in that example that was given to you. Yes, the parties are required to draft a joint pretrial order. But now, what has happened in practice often is that one practitioner doesn't come to the table and doesn't assist in this being drawn. Strictly speaking, a party shouldn't file a one-sided draft order. It's not allowed for in the rules. However, what I have asked practitioners to do in matters where I've acted as instructed counsel and where the opponent seems to be obstructive and doesn't want to come to the table to assist in drawing a draft report, I would draft a one-sided report and file an affidavit. Ask the practitioner to, I wouldn't file the affidavit, ask the practitioner to file an affidavit setting out what was letters that were written and telephone conversations calling upon the opposing side to come to the table and assist and their lack of cooperation. And then the court should deal with it, and whether the court will then accept. I've had instances where one-sided reports were then made an order of court. The court said, well, I'm then accept, you have been deprived of an opportunity now to have insight into this pretrial. I'm accepting the one-sided report. I've also had instances where parties don't agree on what should be in dispute and not in dispute. That happens more often than you would think, because someone interprets this issue to be this, and I may interpret it to be that. Very easy to deal with that. You don't need to run around and address a judge and make a decision. What you do is you can say, the plaintiff says that these are the issues in dispute. The defendant says these are the issues in dispute, and these are the issues in dispute that they agree on. Same with admitted facts. And then the judge has one of two options. Either deal with those during the trial or at the commencement of the trial and make a ruling saying, on the pleadings, I find that this is the issue in dispute. Or on the ruling, sorry, Mr. Plaintiff, on the pleadings, sorry, Mr. Plaintiff, I don't see that this issue that you're formulating here in paragraph 2, that it really actually arises from the pleadings, so it's not something that I'm going to be determining. Or the judge can actually deal with that right at the outset during case management, during the pretrial conference, say, all right, I want the parties to address me on this date. I want to know, or I want to make a ruling on what needs to be decided before we proceed. So the judge really, if it's a fairly simple matter, I suppose you can deal with it during the course of evidence. If it's a complicated matter, then probably deal with that before you set the matter down for trial, because it's important to know, and the parties need to know whether this is an issue that's going to be decided or not, because it will inform a lot of preparatory steps and also how the case is presented. So it has happened in the past. Sometimes these are just parties being overly formalistic and not wanting to, and it doesn't really take, it's neither here nor there. Sometimes these are important issues that need to be determined. For instance, in the example I've given you, if the plaintiff had thought that the reference by a defendant in a plea to acceptance or denial of acceptance then somehow translates into election or waiver, then, and they had listed that as an issue, the court would have had to decide right at the outset whether that was actually an issue in dispute, because I would never have agreed in that scenario for that to be listed as an issue in dispute, because it wasn't on the papers. So if there had been a disagreement between the parties, then the court would have had to decide that right at the outset before the matter proceeds. So you see how it's very important. So a pretrial can become extremely complicated, and it can also be the simplest thing in the world. Depends on the matter. So what I'm saying is I'm being overly formalistic, but I want you to understand that the rules are there for a reason. And even though the court in this instance accepted this pretrial and made it an order of court, it doesn't mean that all pretrial orders can and should look like this. It depends on the circumstances of the matter. I suppose if there are grounds for review, if you feel that one of the grounds for review, you'll be dealing with review and the grounds for review in your motion section, so I won't go into detail of that. But if you feel that the judge has misdirected himself or herself for whatever reason and there's grounds for review, then you have recourse in terms of Section 16 of the Supreme Court Act to, of course, apply for a review of that decision. It's an interlocutory decision, which I don't know if you've read the authority I referred you yesterday to, the Savino versus Nedbank. So it's questionable. It goes back to, it's an interlocutory ruling which the court makes. I think it would be similar to a judge admitting a document into evidence which you've objected to. You can't, even with leave, you can't appeal to that. You'll have to wait for the trial to proceed and to finish, and then on appeal, that would be one of the reasons why you appeal. So you'll deal with that on appeal, because it may very well be that despite that, the trial proceeds and you are still successful. So that's why the rationale regarding appeals at that stage is limited. So even if you obtain leave to appeal that, probably questionable whether the Supreme Court will actually entertain that appeal, because the authorities suggest that in that instance you shouldn't be able to appeal at that stage yet. And the Savinu matter, the authority, it's a judgment given earlier this year, makes it even more difficult for parties in interlocutory decisions to appeal to the Supreme Court. Because what they want to try and avoid is that during this process of a trial, you run to the Supreme Court all the time. All right, so it's an important consideration. You don't want to take the party's right to approach the Supreme Court away, but you don't, because the party can proceed and the Supreme Court can then review the whole process and say, well, this shouldn't have happened. You should never have allowed this to be an issue in dispute, and therefore the appeal should be successful, or whatever it is. So questionable whether you'll be able to appeal that, such a decision. Okay. So pre-trial. So then the list of the witnesses. Please remember, and I'm going to again refer you to the authority of Smuts, Judge Smuts. You are bound by the pre-trial. So if you have left out a name of a witness, then you would not be entitled to call that witness at the trial. When you haven't filed a witness statement, you will not be called or allowed. In this instance, witness statements had not yet been filed at pre-trial stage, so the parties agreed to file by 25 February 2015. Then they say no witnesses to be called by subpoena. You are strictly speaking required to list the witnesses by subpoena. What I have seen happen in the past also is that parties reserve the right to subpoena witnesses and will do so in terms of the rules, and they reserve that right, and then they proceed to call subpoenaed witnesses left, right, and center, probably not in keeping with the spirit of the rules. Parties should actually prepare in advance and list the witnesses they intend to call by subpoena. Now, you don't have to call a witness that you've listed in the pre-trial, so you may list all and sundry and only call 2 witnesses. That's fine. You're not obliged to call a witness that's listed in your pre-trial. Whether the court will make an inference from not calling a witness, that depends on the circumstances of the matter. What happens often, you have all the witnesses listed, but then by the time you get to the second witness, you realize that these issues are no longer in dispute. They are sort of conceded during cross-examination, and then you may not call further witnesses on an issue that you were intending on corroborating previous witnesses' evidence. And then you may decide not to call them, which is actually the prudent course, because you shouldn't waste court time on issues that are no longer in dispute. If something happens, and they do, trials are very much alive, and they very much develop as they go along. And very often issues arise during the course of proceedings that you didn't anticipate, or evidence becomes required that you didn't anticipate would be required. And we all, as I said, don't have crystal balls, and hindsight is perfect vision. So if a practitioner is then faced with the position that he or she wants to call a further witness, you would have to do so with leave from the court. You'll have to amend the pre-trial order. If it's a subpoenaed witness, get that name into the pre-trial order. If it's a witness for whom you can file a witness statement, then seek leave to file a witness statement and to amend the pre-trial to include the name of that witness. And the court will then take a number of things into consideration, especially why this hasn't been done previously, why it's only coming at this stage, at a later stage. because if parties are left, right and centre allowed to just amend pre-trial orders as they wish and at any given stage, then they would pay very little attention to the preparation of the pre-trial order at the beginning, as they should. All right. We'll deal with sanctions after we, well, I'll give you a comfort break in a moment, and then we'll deal with sanctions for the remainder up till tea break, and then we'll deal with contempt and non-compliance and what a judge can and cannot do in those circumstances. So essentially, when a pretrial order is granted, it is an order proper. It doesn't dispose of the matter. It creates certain obligations on the parties, and it binds the parties in other respects. So it's a court order, and non-compliance with that, of course, amounts to contempt if there was an obligation to comply and there wasn't compliance. So as I've explained to you earlier, indexing and pagination is an obligation. A party doesn't have a choice. If they've agreed to that and it's been ordered that it must be done at a certain time, it must be done. Failure to do that will render that party in contempt of court. Dominus litis does indexing and pagination unless the parties agree otherwise or the court orders otherwise. Although the dominus litis, the plaintiff, has the responsibility to engage the other party in the case management process. Where a plaintiff doesn't do so, defendant can't sit back and say, well, then I'm not going to do anything either. The responsibility is just as much on the defendant to actually take part in the proceedings and to then act where the plaintiff fails to act. Now, of course, a defendant isn't going to do something to further the case of the plaintiff. I mean, that would be unfair to expect. But the defendant cannot simply sit back and say, well, I was waiting for the plaintiff, so I'm not doing anything. All right. Okay, so that, in a nutshell, is the pre-trial conference. You'll see just one short note on list of exhibits. The parties, you'll see on page 57 of the example given to you, the lists of exhibits as specified in the parties' respective discovery bundles. Now, strictly speaking, that's not correct in the sense that the purpose behind that is to say which of these documents that you've discovered do you intend to introduce as exhibits during the trial. So I've spoken about a trial bundle earlier, I think it was yesterday when we did discovery. I mentioned to you that I tend to like to prepare a trial bundle, if possible in cooperation with my opponent, to say these are all the documents we intend to introduce. So yes, we have 70 lever arch files of documents, but only one lever arch file is going to be used, and then ideally you should either list them under this heading or have an annexure to the particular to the draft pretrial order where you say these are the documents that I intend to introduce as exhibits. Why the parties do this, this wide sort of all the discovery bundles, is because they don't want to lose out on a right to introduce a document. But you can still have a rider to say these are the documents now identified, but the parties reserve the right to introduce any further documents properly discovered. Okay. Do you follow? And then they deal with plans, photographs, diagrams, and models. Which of these? Anticipated length of the trial. You would say a witness. A substantive witness takes about 2 days to finish in examination in chief and cross-examination if it's a matter of magnitude. In a motor vehicle accident, you'd probably be able to finish about 2 witnesses a day. So here they have 4 witnesses each. So let's say 4 days. So then they say anticipate. The parties are not held to that. It's just to give the court an idea of the magnitude of this matter. Often matters. I've had trials continue for 4 weeks, which we thought was going to take 3 days. It happens. Filing of index and paginated bundles of pleadings. Expediting the trial, none at the moment. So expediting the trial would be to say, I think we can agree on this. These are the 2 experts' reports, and the experts have met, and they agree on these issues, so we don't need to cross-examine on that, or any possible fathomable manner in which the trial may be expedited. And that here they said they don't require further particulars for trial. And then settlement and ADR set out therein. And then that is essentially what a pretrial order looks like. And you'll see on page 60, or draft pretrial order, that pretrial order well, here, for some reason, the pretrial order was not made an order of court, but strictly speaking, it should be made an order of court to bind the parties thereby. So what the court did here was to list the obligations going forward in an order, but not to make the pretrial order an order of court. So I think it would be prudent to do that. All right, so that takes care of case planning, case management, and pretrial conference, the judicial case management system. So we'll deal with sanctions. The judgment I referred to earlier regarding, it deals with an amendment that was sought at the very advanced stage of the proceedings, and then the judge, in his considerations, he dealt with issues relating to the pretrial order and the effect of a pretrial order, the binding effect of a pretrial order on the parties. So you can have a look. It's I don't know whether it's since been reported. It may be. I'll check, but I'll give you the citation on SAFLI. It's Scania Finance. Scania's SCANIA, Scania Finance, Southern Africa Pty Limited. Versus Aggressive Transport CC and another. Aggressive Transport CC. Don't know if I'll send something with Aggressive Transport, but the name is Aggressive Transport CC. And it's High Court case number I3499 of 2011. It's a judgment by Judge Smuts, and it was delivered on 22 January 2014. So you'll know from that the new rules came into operation in April 2014. So therefore here, the judge still refers to Rule 37. But you will recall that I referred to the old Rule 37 conference, which the parties had. It was a one-liner document that they filed. But then Rule 37 was amended to introduce this pretrial procedure before the new rules came into operation. So at this stage, Rule 37 had already been expanded to deal with pretrials. So the principles herein is tried and is still applicable. All right, so that's judicial case management and the process it follows. The parties had agreed to what is set out in the pretrial order. They've signed it and they've filed it at court. So it's a document that's there and the parties are bound by what they've delivered. Of course, you can't rely on things like contempt of court, and something that's a court order obviously weighs heavier than something that's just an agreement between the parties. So to answer your question, yes and no. In certain instances, you would want this to be an order of court because you would want possibly to rely on contempt. It certainly has more substance if it's made an order of court. Let's consider what the rule says for the moment. If we look at Rule 26, the managing judge must immediately after and in any case within 15 days after the completion of the pretrial conference issue a pretrial order on Form 8 in such form as meets the circumstances of the case. So it really is open to the judge how he or she wants to proceed. If we have a look at Form 8, which you'll find towards the end of the rules, you'll see that the judge must, in Form 8, order the issues of fact to be resolved. So those must be made an order of court. It wasn't here. Now what judges do in order to avoid having to retype everything is to say the pretrial order is made an order of court because that sets out these issues. So strictly speaking, in terms of the rules, it is required that it be made an order of court. And in this case, it wasn't, as you can see. So you follow why I say, strictly speaking, it should be, because that's the intention. but it doesn't mean that it's not there. It's there. The parties have agreed to it. The judge just didn't order it. So I, as a litigant, would insist that the judge makes that an order of court. And I do. When I appear in pretrial conferences, I say, my lord, can you please make the draft pretrial order an order of court? And if the order then doesn't reflect that, I'll go back and say, it hasn't been made an order of court. You made the order in court. Can you please rectify the order? Absolutely. But of course, it opens the door for unnecessarily encountering hiccups when you have an opportunistic opponent who says, yeah, well, we may have agreed, but the court didn't make that an order, so I'm entitled to revisit that as I please. You see. So it just opens the door for unnecessary issues. The proper way to do it is to make it an order of court. It should be made an order of court. Then no one can wonder about it. The parties agreed and the court sanctioned it. This is now, it's cast in stone for the moment until the court orders otherwise. So if, for instance, the parties, let's say I want to revisit the list of witnesses I want to call, and there's no court order ordering those. The court never made that an order of court. Do I need leave from the court to change that? Probably not. I don't know. But why go to those issues if it's simple enough to just make it an order of court, as it should be in terms of the rules? Because Form 8 prescribes that that should actually be done. Of course, Form 8 says the judge must actually rewrite everything that's in the pretrial order in an order, which is unnecessary, because a more pragmatic approach would be to say, just make the pretrial order an order of court if the judge is so inclined to agree with what's set out therein. And or the parties should ask the judge, should ask the judge, make an order, make that an order of court, and if it wasn't done, go back and say, you haven't done this yet, judge, please do this, because we need an order of court for the pretrial. So yes, I would never leave it to the judge to do that. As a litigant, I always seek such an order, and I make sure that the order is granted, because after all, it's my client's case. I want it to be properly done. And if there's some oversight, I can't say, well, the judge didn't see this, so what must I now do? The responsibility remains mine to make sure that it is in fact done. Okay, I'm not saying that judges can simply just not do things that they are required to do in terms of the rules. I'm just saying all parties have a responsibility, because the order is made by the judge in court. That is the order. Not what is the written memorial or record of that order afterwards. We just need some proof that this order was granted, which is why court orders are written down and issued. But the order is what the judge says in court. So if the judge in court says the pretrial order is made an order of court, and it's not reflected on the written document, the party should go back to the judge and say, you made it an order of court during the proceedings, but it's not, so that is not a correct reflection of the order that you made. Because remember, the judge gives the order in court, in open court. Yes. And then it's written down in an order afterwards to have a written memorial or record of what transpired. That document is a draft pretrial order.
It's a draft?
It's a draft pretrial order that sets out the issues. The court must still issue and give an actual order.
Oh, okay.
It's not indicated on that paper. It's indicated on the actual document. So what must follow is an actual order. So the court looks at this draft document that you've given, and that doesn't become the court order. There's a subsequent actual court order based on what the judge ordered in court. So the last slide for this session, which is actually just a continuation of what we did yesterday before we proceed to interlocutory matters for the remainder of the day, is sanctions. So it's important, and it's very important for you to read Rules 53, 54, 55, and 56. This really, and I'm not saying, please don't, or please proceed looking at those rules from this perspective. It's part 6 of the rules. The High Court has inherent jurisdiction. So in any possible permutation of sanctions having to be imposed, it's a guideline of what judges can and cannot do, but that's not to say that that's all a judge can do. Are listed here for failure to comply with the rules, with a practice direction, a court order, or a direction given by a judge. So it tends to guide a judge on what to do and not to do in such instances. So if any party or his or her legal practitioner, if represented, without reasonable explanation, fails to A, attend a case planning conference, case management conference, a status hearing, an additional case management conference, or a pretrial conference. B, participate in the creation of a case plan, a joint case management report, or a party's proposed pretrial order. C, comply with a case plan order, a case management order, a status hearing order, or the managing judge's pretrial order. Or D, participate in good faith in case planning, case management, or pretrial process. E, comply with a case plan order or any direction issued by the managing judge, or fails to comply with deadlines set by any order of court. The managing judge may enter any order that is just and fair in the matter, including any of the orders set out in sub-rule 2. So you see what I'm saying. It's a guideline. It's not a limitation. The managing judge can make any order that is just and fair in the circumstances. Now, what sub-rule 2 says what a judge can consider doing is 1, and this is without derogating from any power of the court under these rules, the court may issue an order to A, refusing to allow the non-compliant party to support or oppose any claims or defenses, striking out pleadings or part thereof, including any defense, exception, or special plea, dismissing a claim or entering a final judgment, directing the non-compliant party or his or her legal practitioner to pay the opposing party's cost caused by the non-compliance. Okay, now let's consider for a moment in practice. A party is called upon to attend a case management, the parties are called upon to attend case management conference. Case management conference is set down for, you all have written down, so I can delete this now, or clear it up, or whatever it's called. So the parties are, case planning is done, pleadings have closed, and the parties are required to attend a case management conference. The court says, all right, parties, you are to attend a case management conference on 16 November. Okay. 16 November comes, the plaintiff is there, and the plaintiff has filed a one-sided case management report, and the plaintiff has filed an affidavit. The defendant is not there. Whether it's the look, I mean, if a party is represented, the defendant doesn't physically need to be there. The representative is there. And as I said, I may be instructed counsel in a matter, but my instructing counsel can stand in for me. I don't also have to be there, as long as a representative is there. A representative who is informed of the matter. So you can't send someone who's just received the file and doesn't know. He or she must be able to address the judge on issues relating to the matter. So it must be someone who's competently informed of the matter. So now this is what you're faced with. On the 16th of November, Mr. Plaintiff or his lawyer is there. They filed a one-sided case management report. And in the affidavit, they said, defendant ignored me. I sent 2 letters. They are attached. I've made telephone calls. I left messages. The defendant has simply not engaged me at all in respect of the drawing of a case management report. Moreover, the defendant didn't file its discovery, which it had to do by 10 October. So what do you do now? You are now the judge. This is now what's transpiring before you. What do you do?
Of the date of the conference.
No, remember now,
No.
your case management conference date was set in court at the case plan conference where both parties were present. And then a court order was subsequently issued. I'm the plaintiff. I say, my lady, I act for the plaintiff. I have filed, or my instructing practitioner has filed a one-sided case management report. This matter is set down for case management today. It was previously set down in a case management or a case planning conference where both parties were present. The defendant is not present here today or represented here today. We have also filed an affidavit explaining that the attempts made by the plaintiff to make contact with the defendant's practitioner, who is still representing the defendant, and the defendant has not returned any of our calls or any of our pleas, so we were constrained to proceed in that fashion. I'm in the hands of the court. Those are my submissions. I'm in the hands of the court. The rules says that you can make these orders when there's a non-compliance. Okay, so what you'll see in the rules, and it's important, is that the rule says you can issue sanctions. So I may actually get up, I might be very eager to get judged and say, a judge or my lady, this is what happened, please strike their defense and give me default judgment.
Exactly.
But that's not to say that you should be giving it then. Okay. Because what the rules say is that without a reasonable explanation, where a party does that without a reasonable explanation. So you now know that we now objectively can establish that there has been various non-compliances in this matter. But for all you know, the defendant's legal practitioner may have died in the meantime, to take an extreme example. Okay, so there may be various reasons why there's been non-compliance. What should happen then to give effect to justice is that an order is made calling for a sanctions hearing. Okay, sanctions hearing. So what you would do is you would say the defendant or his or her legal practitioner is given an opportunity to make oh my word, don't tell anyone. I spelled affidavit that way. Okay. So you can't present evidence before a court by way of oral representations unless you take the oath and actually get up and want to. But I can hardly think that a judge will ask counsel who's robed before him or her to actually just take off their robe and go and stand in the witness box. That's not how it works. So you'd expect an affidavit, and that's why the practice is to give practitioners or to give parties or their legal representatives the opportunity to file an affidavit explaining the non-compliances. Okay, and that will be set in a date, let's say 5 December. So it's a future date, a reasonable time. 2 weeks, I suppose, is a reasonable time. And then, of course, you need to, on the 5th of December, make sure, if nothing is received, you need to make sure on the 5th of December that this order did actually go and find its way to the defendant or his legal practitioner, which is why the rules make provision for that to be sent by the deputy sheriff. And what I would do, because now remember, I'm going to say to you as plaintiffs counsel, I'm going to say, my lady, on 5th of December, I'm going to move for sanctions. So I'm going to be there, and I'm going to be sitting there like a vulture waiting to get my default judgment. So as a prudent litigant representative, I would say, as I've done, I will also make sure that this order is served on the defendant and or his legal practitioner by the Deputy Sheriff, so that we're all sure on the 5th of December that the defendant or his legal representative received this order. It depends on whether the defendant is acting in person or by virtue of a legal practitioner. Now let's say on the 5th of December a number of things can happen. One, that legal practitioner has since withdrawn. It's simply filed a notice of withdrawal of representation. Says, I'm no longer representing this party. That's all you have. It won't be either or. It's either the defendant, if he or she appears personally, or it's the legal practitioner, if it's Remember, a litigant chooses, by his own accord, legal representation. Okay, so a litigant is bound by what his or her legal representative does. You can't say, well, I mean, I didn't know they were going to do that, so shouldn't be bound by that. Your legal you say to court, this legal representative can act on my behalf. And therefore, the court will call on the legal representative to make the representations. Now the legal representative has just gone and withdrawn. In this scenario, I would say probably prudent to make sure that the defendant is also aware of what's happening. Does the defendant know that his legal practitioner has withdrawn? Does the defendant know that his legal representative was required to make representations? Does the defendant know that we're in court today? So you'd probably, if you want to avoid a short-lived order that's for which rescission is applied, probably cross all your T's and dot all your I's by saying, all right, this has now happened. I want to give a cost order de bona because he or she was called upon to make representations. You can't simply go and file a notice to withdraw. You have an obligation under court order to file a representation saying what's happened. But it now may very well be that you are innocent in this whole issue. So all you've done is you've just ignored my court order here. So you are in contempt, and I'm going to give a de bonis order against the legal practitioner. But that's now an issue aside. The other issue remains, can you now in these circumstances give an order that's going to be detrimental to the defendant given now a further non-compliance by his or her legal practitioner? Probably not. In the interest of justice, you should probably avoid because if you made an order, you've made an order. Then there must be an application for rescission, etc. So before you make the order, probably establish what the situation is regarding the defendant. We're not assuming anything. We're just not sure that the defendant knows. If this doesn't happen, the legal practitioner doesn't withdraw, you never need to mind yourself with whether or not the defendant whether this person has told the defendant that there's this happening, because he's represented. So you can accept that once the lawyer is informed, the defendant is informed. Okay, but now there was a withdrawal, so you have to just first make sure what the position is regarding the defendant. Okay, let's say on the hearing of the sanctions, nothing happens. It's just the plaintiff who's there. You get nothing. Believe it or not, this also happens. You get nothing. So I'm there, I say, my lord, strike his defense, I want default judgment. And will you grant that order? There's nothing, no withdrawal, nothing. There's nothing before. There's proof that the order was served, and there's nothing more. On the legal practitioner. It's a represented, or a defendant himself, whichever one is applicable, that's been served on them. Would you grant the order that I seek on 5 December in this scenario? So what practice are you promoting when you have that approach? I don't have to go, the court will phone me. I'm so important, I don't have to be in court. The court will actually phone me to ask whether I can be there or I'm coming or actually going to grace them with my presence. So you don't want to create such a culture and a practice, and you don't want to promote that. So I personally, and I can only tell you what my personal view is towards this, is that in such an instance where you know that the order came to the knowledge of either the defendant or where represented to the legal practitioner, and on the 5th of December there were sanction hearings, or for the sanctions hearing, nothing has been forthcoming, the court should order. Should make the order it's entitled to make, because, of course, not only has there been non-compliance, that party has chosen not to make any representations or to file an affidavit in order to address this. So in my view, on this day, if nothing happens, make the order. Make the order. No court and no clerk of a judge is required to call parties to say, oh, did you know that you were required to be in court? Are you coming? Should we wait for you? Once the court has made an order imposing sanctions, the court is functus. If you want to set aside that order, you need to apply for that order to be rescinded. Absolutely. That's why I said where there's been a withdrawal of a legal practitioner, although you are entitled to assume that the order was served on a legal practitioner prior to withdrawal, that the defendant is aware of it, I would be wary to proceed against the defendant unless you know what his or her situation is. So yes, of course a court can order a legal practitioner to come to court. Look, I mean, your sanctions hearing was, you called upon a party to make, you gave them the opportunity. If they didn't want to use it, sanctions will follow. You can order a legal practitioner, despite a withdrawal, to appear in court. That's happened. I've seen colleagues being called to court by a judge, saying, you will appear before me tomorrow at 10. I want to hear you on what has happened here and why you have withdrawn. So that can also happen, of course. But yes, where a legal practitioner has withdrawn and nothing further has happened, I would first want to establish what the position is regarding the defendant before I simply make or impose sanctions. Well, your hands are not tied. You can say, I'm not postponing this matter. You can go get yourself another lawyer, but I've given you a number of opportunities. So we're proceeding with this trial with or without your lawyer. So that you can do, depending on the circumstances. But a judge can never force a party to be represented by a specific practitioner, ever. That remains the party's own choice. But what the judge can disallow is to be led by the nose in delays and postponements by a party who jumps from one lawyer to the other. So the judge can say, after the first or second postponement for change of representation, say, this is the last time. I'm not going to postpone this matter any further. You've had your chance. I'm proceeding with or without your lawyer.
Okay, so
but that'll depend on the circumstances.
okay.
As long as a party is given a fair opportunity to bring representation of his or her choice. Sometimes judges postpone matters in order for a party to get representation. It's postponed for 2 months, or the trial is postponed for 2 or 3 months. Then comes the day on the trial, and the other party says, I haven't found a lawyer yet. That's too bad for you, I'm proceeding. It's frustrating, but remember, the rules of the High Court make provision that a party may not withdraw. I don't remember the exact time period. I think it's 30 or 60 days. I'll check during the break, before the trial, due to financial reasons.
Okay.
So you need to get your finances in order well in advance of the trial. It's exactly to avoid that circumstance. Right. So if you are lax in securing the requisite deposit from your client in advance, then you are penalized by the court saying then you will proceed with this matter. You're not allowed to withdraw. I'll check during the tea break and I'll let you know. I don't have it. Look, I mean, I don't do representations and withdrawals. I act on instructions of lawyers, so that's not on the tip of my fingers. But I know there is such a requirement. I'll check during the break, and I'll tell you which rule it is. The court's approach in the High Court in civil litigation towards lay litigants acting for themselves is simply, I'm not going to excuse you because you're a lay litigant. You need to acquaint yourself with the rules. You need to know the forum that you're operating in. I'm not going to be bending over backwards to assist you, and I'm not going to assist you. You need to shape up or ship out. So lay litigants are not allowed leeway other than lawyers. Of course, when it comes to heads of argument and things like that, the court is going to be more lenient in the sense that a lay litigant is either not required, or heads of argument, or when there's less than perfect pleadings and there are technical issues, the court will probably be less stringent because it's a lay litigant. Although, strictly speaking, if you want to proceed on your own without representation, then you should know the forum that you're operating in and know the rules that are applicable. Okay, so let's say shortly before the tea break, what did I do with my blue? So let's say, okay, we have a very good legal practitioner, and he now files an affidavit. He's now there on the 5th of December, and he says, I was overworked. I had so much work that I overlooked this matter. I was very busy. I was very, very, very busy. And so I just overlooked this matter. Just being very honest. Saying I was overworked and I overlooked this matter. What do you think? Think it's a reasonable explanation? So what are we doing if we're saying to lawyers, okay, you know, shame, you know, you're busy. No problem, next time. I can tell you, I don't think there's anyone in this practice of the law that's not inundated with work. We all are. You need to learn to operate. So in my view, that would probably in the circumstances not be a reasonable explanation. So what you would expect is you would expect a reasonable explanation explaining exactly what was done and what wasn't done. So a full and frank explanation. Let's say the lawyer says, you know what, my father died and I had to travel to the north to attend to the funeral. I left this matter in the hands of an associate who didn't attend to it properly, and upon my return I received this order that I had to be here on the 5th of December. Would that be a reasonable explanation in the circumstances? Probably would. And you can also be guided by, well, I mean, over time you'll know certain litigants have a sort of a pragmatic approach to opposing these types of things so if I was the opponent and this had been the explanation, I would say, want to argue this? I want my sanctions. You haven't reasonably explained the delay. Here I'd say, my lord or my lady, I'm not proceeding in assisting in sanctions. Can it be condoned, and can we please proceed and issue a new case management order? So it depends on the circumstances. So you see how these things permeate and how it depends on the circumstances. But be mindful of the fact that when you are imposing sanctions in terms of Rule 53, that you should do so where you are certain that the party against whom you are making this is actually aware of the responsibility that he or she had, and that you had given the opportunity to make representations. And remember, not evidence from the bar. The lawyer can't pitch up their robe in hand and just to throw it on and say, I was so busy. And there must be something on affidavit. You have to have evidence before you to consider. Okay, I think we can break at this point, and I'll deal quickly with the other 3 rules after the tea break. Any questions before we leave on this? Good. See you after the tea break then.